Hi, Connecticut attorney Ryan McKean here. I'm here with Connecticut medical malpractice attorney Jake Kosianda. Hey, Jake.
Good morning. How are you?
I'm doing well, Jake. One of the things that we get asked a lot, we get a lot of phone calls for Connecticut medical malpractice cases, is, if I'm hurt or I'm injured by a doctor or hospital, do I have a case? And I'd like your take on that.
Sure. That is a common question we get, and it's partial yes, partial no. You have to be injured in order to bring a malpractice suit, but the injury alone doesn't allow you to bring the suit just because you're injured. Unfortunately, in medicine, it's not a perfect science. People have very bad outcomes. Good people get hurt all the time. It doesn't mean anyone did anything wrong. The key to a malpractice suit, or the thing that makes it a malpractice suit, is negligence, and that is that the doctor, the nurse, the clinicians did something that they shouldn't have done or didn't do something that they should have done. But it's not just being injured. And so that's why these things can be complicated. You have to look into them to find out a lot of information about what it is that went wrong and should have gone right.
Now that's in contrast to things like a dog bite. Under Connecticut law, if you're bitten by a dog, the owner, they're strictly liable for those damages. And strict liability means that if it happened, you're responsible for it. And medical malpractice it's more like a car accident, right? Where we've got to prove that somebody ran a stop sign, correct?
Yeah, in fact, that's a good analogy because some car accidents, it's very intuitive, very obvious someone made a mistake, like a rear ender, right? If you're stopped at a light and someone rear ends you, there's not a lot of debate. Did someone do something wrong? Medicine's a lot more complicated, but there are variations. Sometimes it's extremely obvious a doctor did something wrong or a hospital made a mistake. But a lot of times it can be a lot more complicated and very nuanced based on the facts, and that's why sorting these things out can really take some time and some effort. But you don't know until you get into the weeds and start looking at things.
Several years ago, I was able to go to a seminar by one of the best trial lawyers in the country, and he said that, look, every case is about a stop sign and somebody running the stop sign. And what you have to figure out in your case, whether it's a commercial case, a medical malpractice case, workplace injury case, any kind of case in law, you have to figure out what the stop sign is, and you have to, show that the defendant didn't stop. Essentially, would you say that that is true for your medical malpractice cases? And if so, how do you go about finding that stop sign?
Absolutely. It's a good analogy. So just like in the ordinary day-to-day activities, we have certain duties and standards to uphold. Stop sign when you're driving, you stop at a stop sign, stop at a red light. If you don't, that's negligence. Medical world is the same way, in the sense that they have their own rules and regulations, things that they have to follow. The difference between a motor vehicle case and a medical malpractice case is that we all drive, and so the average person understands those rules. In medicine, we're not all doctors, we don't have the training, and so that's where it's a specialty. And you don't know, without consulting with doctors and medical professionals, whether or not there was a stop sign and whether the person stopped at that stop sign when they were treating you. But the very basic is it's the same. It's not following certain duties and obligations you have, and as a result of that, injury or bad things happen to somebody.
Now, if look, in Connecticut, in any state, you can go and you can, file a lawsuit yourself, right? And if you think you've been the victim of medical malpractice, I mean, is that something you can do? Just go down and file the lawsuit, or is there something that you would have to do first in order to even get the lawsuit really into court? And I mean, you can physically file something, but ultimately have it dismissed. Can you explain that process of what it is that you have to do if you are, as an attorney, bringing a medical malpractice claim?
Sure. It sort of goes right back to what I was just saying, and that is we're not all driving in the medical world, so we don't know what those standards are, and the law acknowledges that. If you brought your car down to a mechanic, you don't know what the mechanic's doing unless you happen to have that education or skill level, so you have to trust the physician or trust the mechanic, and the same thing goes with a malpractice suit. We have to get another physician or nurse or someone who's in that medical field, that discipline, to essentially look at it and find that there's sufficient evidence for malpractice that might have occurred before we can bring a suit. And we have to get a signed letter from those clinicians that we attach to the complaint before we file it with the court. I or a patient can think very strongly that someone made a mistake, that malpractice occurred, but the court really doesn't care about what I or even the patient thinks. You have to have that letter. And like you mentioned, without that letter, the court will throw that case out no matter what you file. And if you don't get it within the statute of limitations, you don't get another chance.
Now, there are very, very specific rules for that letter. And one of the things that you had mentioned is that you have to get it, it has to be attached when it's filed. And look, you do this day in and day out. How long does it take you as a very experienced medical malpractice lawyer to find the right experts or find experts who are qualified to give you a certificate of good faith? And what is it that you need to get to them?
Sure. So the first thing, well, to answer your question directly, it could take quite a while to find that expert, but not because the experts aren't available, but because you don't know who to hire or what medical discipline you need. One of the problems with medicine, we don't practice medicine, we don't train in it, we have to figure out where things might have gone wrong. So we get the medical records. If it's a single office visit or maybe your PCP, that might not be a lot of records. It could be 10, 20, 100 pages. If it's a hospital admission, it can be thousands of pages. I've had cases where we're in the 6, 7, 8,000 pages are generated from a long hospitalization. Those take time to get. It can take 30 to 60 days to get those. It can take time to review them to kind of figure out what happened, the sequence and the chronology of events, and then figuring out what discipline you need. And all that takes a lot of time. We're talking months. It could take 3, 4, 5, 6 months before you actually get an idea of what medical field we need that expert in, and then to hire them, and very often we need more than one.
And so, for example, one of the things is like, my understanding of the law is you need an expert who has the same qualifications as the person that you think committed medical malpractice. Now, if you went out and you got, say, the head of Harvard Medical School or somebody with immense qualification, but really it's that you think it's a nurse who is the person who committed the malpractice, would their opinion be enough, or do you have to get somebody who's a nurse?
It depends on the circumstances of the case. Sometimes a physician can provide that opinion letter we need about a nurse if the discipline, the medical field is the same, and there's certain issues with the training and the way they work together. And sometimes not at all. In fact, sometimes it's absolutely not going to work. In that case, we'd be thrown out as if you didn't have the letter at all because it's the wrong medical field.
So, my takeaway from this is that it's very complicated. It takes time. You need somebody to really navigate it. And, if somebody else is out there and they're thinking about this, do these experts typically charge money to review these records? Like, how does that work? Or are there services, like, do you find them online and they just give you a quick opinion? Can you talk a little bit about that process?
Sure. Most medical professionals don't want to be involved in litigation in any way, shape, or form, whether it be defendant or whether to be involved as an expert witness and hired and paid for their time. So there's very few that actually want to get involved simply because they're spending their time practicing medicine and healing patients and treating them. So finding those that are actually willing to go into the court system is sometimes very time consuming. There are services that we can use to help find them, but often it's just a matter of cold calling and talking to the experts of good caliber with good background and experience and seeing if they're willing to take a look at a case and assist the patient in litigation who got injured. And that takes time. That takes a lot of footwork. It takes a lot of calling. And it also takes a lot of effort to understand what to explain to them and how to explain the case, because ultimately they have to decide if they think they're appropriate and they want to be involved. If you don't know what you're talking about as an attorney, then they're not going to want to help and deal with you at all because they understand that it's going to be too much problems and too much work for them.
Now, how long in Connecticut does somebody have to bring a medical malpractice case?
Generally speaking, it takes you have up to 2 years. There are some exceptions for continuity of care and continuous conduct doctrine. There's also when you learn of the injury. An example of that would be if you have a test, let's say it's a CT scan or an X-ray that shows a nodule on your lung, and your doctor misses it completely and you get diagnosed 4 years later. that could be an extension of that statute of limitations, and so that the 2-year limit runs when you're diagnosed as opposed to when that CT or X-ray was taken. But it's really dependent on the facts and the circumstances.
So it's different, a lot of people out there may be familiar with like car accidents in Connecticut, and that's a 2-year statute of limitations. That's pretty easy. You know the day that somebody rear-ended you, and then it's 2 years from there. And so what I'm hearing is that medical malpractice is more complicated than that potentially.
It really is. It's much more fact-driven and nuanced in the sense that you have to know a lot more about the medicine and the way the medicine was provided and the medical services were provided to know when the statute of limitations began to run and when that 2-year time limitation runs. There's also a wrongful death statute, which is a little different, that can give you up to 5 years under some circumstances. But again, you really need to know those. You got to get those medical records to understand how the care was delivered and provided and all the different nuances of the interaction from the providers. It's very rare for a case to involve just one medical provider. Most cases have to deal with lots of different disciplines and specialties and care providers all wrapped into the care. And sorting through all that can be why the statute of limitations is a little difficult to determine right away.
So, if somebody's out there and they've made it to this point in the video, it's probably because something significant has happened to them, or they feel like something, they've been wronged by a doctor or a hospital or a loved one has, and they have a lot of questions. When should somebody contact a medical malpractice attorney?
It starts when a bad thing happens to a good person and you don't understand why and you don't believe it should have happened. That's all that matters at that point, and then that's when I would be able to get involved and start looking into it for you. Many times it's not a problem with the medical field. Sometimes the human body doesn't heal or there's diseases and conditions that we can't cure, but it really starts with just having a bad outcome and feeling that that isn't what should have happened. Your expectations were different.
So should they, contact you immediately to start having their case reviewed, or is it something that they can just wait on?
Definitely, as soon as you feel something went wrong, that's when you should contact me or any attorney for that matter to start looking into it. We have the expertise to look into it and get to that point as fast as possible. But if you wait too long, there might not be enough time to look into it, even if the statute of limitations has run, because the statute of limitations requires filing before a deadline. And as I've explained, we have a lot of work to do to get to that point. So you don't want to wait till the last minute. You really want to start that process as soon as you feel something went wrong that shouldn't have.
Now, when I've taken these calls, one of the things that some people are concerned about is maybe they like their doctor. And if they come to an attorney, a Connecticut medical malpractice attorney, and they ask for their case reviewed, is anything bad going to happen to the doctor?
No, not at all. In fact, very few cases we review actually result in a lawsuit, and the doctors don't even know, and the hospitals don't even know we've looked at the case. Nothing results to the doctor to their detriment simply because we're looking. Really, it's when the case is filed in the court that they get put on notice that there's a claim, and at that point, they'll alert their insurance carrier. They all have liability medical insurance, just like motor vehicle insurance, that covers the claim. They'll put them on notice, they hire them an attorney, and the process begins, and the doctors just continue working and practicing medicine and delivering care while they have an attorney assigned to them who's going to help with their defense.
So that's important to know. I think it's a confidential process if they contact a Connecticut medical malpractice attorney, and it's just good to get that peace of mind. And to have those questions answered, and even if the answer is like, look, there's nothing we can do, or we don't think that there's medical malpractice, or we do, really getting that closure and peace of mind, there's no real consequence to somebody doing that.
Not at all, actually. In fact, one of the number one statements I get from the people who call are not that they want to sue a doctor or hospital. They want answers as to what happened. They just don't understand. One of the problems with the medical community is they don't explain things really well enough for the patients to understand. And they look to me very often to just help them figure out what transpired and how they got to the point they're at. And sometimes the answer is there. It's just not a lawsuit, but I can help them understand a little bit from looking at the records and talking to them.
Now, Jake, you're very successful lawyer, and some people think, oh my gosh, I got a lawyer, got to pay a lot of money. I'm going to have to pay them a lot of money to get, this advice or this counsel. Do you charge if somebody calls you? How does that work?
There's no charge to call. There's no charge to talk. There's no charge to look at the medical records and start the process to see if there is a claim at all. Our fee is essentially based on what we recover. It's called a contingency fee. And if we recover any amount of money for the patient or for the person who's harmed, that's when we get a fee, and we get a 1/3, 33 1/3% of what that fee is. If there's no recovery, there's no fee paid, and we don't get paid, but there's no expense and there's no obligation to the patient or the client that hires us to look into the case.
I mean, one of the things that often gets talked about is access to justice, and there's a lot of lawyers out there, but yet most ordinary people like me, they can't hire a lawyer. Maybe they can't afford a lawyer, or they don't know a lawyer, and so I think the law got it right, probably about 40 years ago, when it was like, well, nobody plans on being in an accident, and we want to have people be able to have their questions answered, and so to allow sort of contingency fee agreements where, again, our incentives as a firm, your incentives as a lawyer, and the client's incentives are aligned, which is we don't want to bring any case without merit. Because ultimately we don't get paid. It's not good for us. It's not good for society. It's not good for the client. And so, this idea that, somebody out there watching can contact a top attorney in any field, I think is such a powerful one. Jake, anything else that you would want to share with somebody who's out there and they're, wondering what to do?
Not much other than what we've covered. If you have any idea that something went wrong, or you're just wondering, that's when you call me, and hopefully we'll be able to get you some answers. It may not be a lawsuit, but it may bring some peace of mind, and that's really the most important part. Keep in mind that at the end of the day, your health, the patient's medical care is the most important above all. And so that should never be stopped and should never be overlooked when looking for a lawsuit. But ultimately, if you're just looking for some answers, we can often help without even having to bring a lawsuit. And if the lawsuit's appropriate, we'll advise you of that.
Jake, I think that's a very important note to end it on. And if anybody out there has any questions, don't hesitate to give Jake a call, 860-471-8333. We are happy to help you look through your case and, answer some of your questions and give you that peace of mind.